Thank you everyone for joining us this morning. Today we will talk about the National Interest Waiver. My name is Jiyae Hwang. I am a senior associate at Scott Legal PC. And I have extensive experience in processing a wide variety of EB2 NIW cases. Um, and especially, I specialize in assisting entrepreneurs and a wide variety of professionals pursuing this pathway. So today we'll focus on the NIW, talk about this green card pathway that allows self-petitioning for certain individuals who have advanced degrees or can show that they have exceptional ability and are coming to the United States to do something that the government will find that it is in the national interest, such that they would be considered exempt from the ordinary requirements of getting a labor certification, getting a job offer from a U.S. company to sponsor them. It is definitely one of the more discretionary benefits. So definitely, it is important to prepare a strong package with a persuasive argument to, convince the government that the person would, qualify for this benefit. Now, let's go over a few housekeeping things before we get started. Scott Legal is a full-service immigration law firm, which means we have expertise handling a wide variety of non-immigrant and immigrant visa categories suited for various circumstances. So whatever your immigration needs may be it a family-based, employment-based, or investment-based immigration matter, we can help you find a solution. We will be continuing this webinar series, and we are doing at least 2 webinars a week on different immigration law-related topics. And at the end of this webinar, we will be sending out a few things for the benefit of all participants. We will send you a copy of the PowerPoint that will be used in this webinar. We will also send you a visa guide, which is a comprehensive guide that goes over the requirements of the NIW that you can use as a resource. We will send you a link that you can follow to sign up for any upcoming webinars in the future, and also a link to this webinar as it will be recorded. This webinar will also be made available on YouTube. And we do encourage you to subscribe and hit the notification button, as we regularly do upload a variety of immigration videos that could be a helpful resource to you. Finally, we'll send you a link where you can follow to set up a consultation with me or any other experienced attorney at Scott Legal if you wish to discuss your particular case in further detail. I'm happy to be presenting today. I'm a senior associate at the firm with a wealth of experience successfully processing and securing approvals for a wide variety of EB2 NIW cases in many different fields. And I'll be sharing my insights on how you can qualify for a green card under the EB2 NIW category. Finally, if you have any questions, I'll be happy to answer them. Please feel free to add them to the chat box or the Q&A function, and we will try and get to all questions. I will start with the presentation, but I will definitely leave some time at the end to answer questions via a live Q&A. So please feel free to do that. So yeah, without further delay, let us get started with the presentation. All right. So first, let's go over the general facts about what is an NIW, what does it mean, and how would you qualify. So an NIW is short for National Interest Waiver, and it is a green card option that is available to applicants if the government concludes that you're coming to the United States to do something that is in the national interest. And the national interest is necessarily quite a broad concept, right? So there is a case called Matter of Dhanasar, which provides a framework for officers that they follow. So basically, what does it mean when a case is in the national interest? So, and cases will need to meet the three-prong Matter of Dhanasar test to show that their work is in the national interest. So that is a key part of qualifying for the NIW. Now, it is important to note that the NIW is a subset of the larger green card category, the EB2 category. And so the EB2 category, you can think of it as a broader classification that includes non-NIW cases and NIW cases. Now, for non-NIW cases, which is pretty much the majority of the cases that are filed under the EB2 classification, requires a job offer, requires a US company to sponsor the foreign national. And this US sponsoring company must go through what is called the labor certification test. It is a process where, you would get a prevailing wage, and then you would, the company would do a particular period of recruitment and show that even if there are applicants, there is nobody who's in the US who is a US citizen who meets the job requirements for that particular position. And only if the company can prove that, they can go ahead and sponsor the foreign national for the green card. Now, this is a very complicated and time-consuming process, right? And not all people may, even have a US job offer from a US company that is willing to sponsor them. So the NIW is advantageous for those self-petitioners who don't have that US job offer, or even if they do have a job offer, if they want to avoid this time-consuming and costly process of the labor certification test, this is the alternate pathway that someone can take to qualify for a green card. But naturally, because you're asking for an exemption from the ordinary requirements of a labor certification, the NIW has a much higher bar than perm-based company sponsorship. And this higher bar means that you need to be showing that you're doing more than what an average worker does who has the minimum credentials. If you are an engineer, you can't just say you're coming to be an engineer and helping one company, because that's what you do when you're being sponsored for a job. And in order to convince the government that you're doing something far superior or far more impactful than what the average worker does, that's the key for the NIW. You need to show that you deserve an exemption from the ordinary sponsorship requirements. That's why the NIW can be a challenging petition, right? So qualifying for the NIW, you need to meet a three-part requirement test, and that is based on a recent case called Matter of Dhanasar that came out in December 2016. And in addition to meeting the Matter of Dhanasar criteria, you must also meet the EB2 threshold requirements, and we'll go over that in a little bit more detail. Basically, you need to show that you either have an advanced degree, a master's or above, or a bachelor's degree and 5 years of progressive work experience in your field related to the proposed endeavor, or if you can show that you have exceptional ability in the sciences, arts, or business. Now, as I mentioned in the previous bullet, you do not need an employer to apply for a national interest waiver. So national interest waiver is a category where you can self-petition for a green card, which is one of the reasons why it's so popular and a lot of people are interested in this pathway. And the waiver relates to the EB2 requirement to prove that the employer cannot find a qualified US worker. And I did talk about this already, but this is the perm labor certification requirement. Now, the challenge for the NIW is proving why your case merits an exemption from this ordinary requirements of a job offer and labor certification, because the nature of your work is such that it goes far beyond what an ordinary engineer does, an ordinary lawyer does, an ordinary, scientist does. But you are impacting the field in a broad way. You are, providing a national level scale, benefit to public health, or, veterans welfare, or improving best practices in manufacturing, things like that. If there is that plus factor in what you're doing, that can be a basis that the government finds that your work is in the national interest and would merit an exemption from the ordinary requirements to have a job offer and get sponsorship from a US company. Now, the last thing to mention before moving on to the next slide is that applicants in any field can apply for an NIW. And definitely, it is not true that only STEM people can apply. That's not true. Only entrepreneurs can apply. That's also not true. Only pilots can apply. That's also not true. It is really not what you're doing. It is really not what your field is, where you're operating, but it is what you're doing within that field, right? So just just being somebody who's an engineer who, develops AI technology, that in itself will never be sufficient to have, to give you a NIW approval. Now, and especially now, the government is looking very, very strictly on the distinction between the importance of the field and the importance of what the person is doing in that field. And the latter is what matters, right? So even if you're working in a very attractive field such as AI, if all that you're saying is, oh, I'm going to come into the United States and work for Google as an AI engineer, that is no longer a viable basis for a successful NIW case. And that's definitely a point that I want to really drill down because it is definitely a common misconception that the field is what matters. It's not true. Applicants in any field can apply, but what is important is how you show an impact within that field and a broad impact within that field. And we've had approvals for lawyers, actually, right? So people like lawyers can apply as well, as long as you can show you have had a broad impact on advancing the field of law as a whole in your particular niche, right? Just working, as a lawyer will definitely not be enough. But if you're someone who is that impactful, then yes, you can consider an NIW. Similarly to people in the humanities, if you're, someone who's developing a new kind of literary critical theory, and if people, like hundreds of people, are citing to your work, and if you're being invited to conferences to present about your cutting edge research, definitely you can think of a argument that you qualify for the NIW. So really the specific proposed endeavor is important, what you're doing within that field, rather than what is your field. All right, so now let's look a little bit closer at the threshold requirements. The EB2 category, and as I said before, there are two types of EB2 green card cases: the perm category, where you have a US job offer from a US company, or the NIW aspect, where you prove that you don't need a US job offer because you meet the Matter of Dhanasar requirements. In either situation, you still need to meet the EB2 threshold requirement, which can be met either by showing that you have an advanced degree, which is defined as a master's degree or higher. So a master's degree, Master of Science, MBA, that works. A JD, for example, or an MD, if you're a doctor. Those kinds of degrees also work because you typically need a bachelor's degree to gain admission to those programs. So that also counts as an advanced degree. Or if you have a bachelor's degree in your field, but if you also have 5 years of post-baccalaureate progressive work experience in your occupation that is related to the proposed endeavor and related to your degree, then you could also be considered an equivalent of an advanced degree holder. So let's say you are an engineer and you had a bachelor's degree in engineering, and then you had 5 or more years of progressive work experience in engineering, then you can meet the EB2 threshold that way. Now, it is important to note that the work experience needs to be progressive. So the government will expect to see a detailed employment confirmation letter that shows not only that you've worked for the full 5 years in aggregate, but also that your job duties changed, increased in complexity, and increased in terms of responsibility over time. So maybe you started off as a junior engineer, but you were promoted to senior engineer, principal engineer, and then you were, responsible for increasingly complex responsibilities over time. A detailed letter from your previous employer attesting to that would be required to prove not only that you have the bachelor's, but you also have the 5 years of progressive work experience. So definitely important to note that nuance as well. Now, let's say you don't have a degree, you don't have a master's degree, you don't have a bachelor's degree. You can also meet the alternate way, meet the requirements with the alternate way by showing that you have exceptional ability in the sciences, arts, or business. And the way to meet exceptional ability is to show 3 out of the 7 criteria that's listed in this slide here. So if you have any degree related to your occupation, if you have 10 years of full-time work experience, if you can show that you have commanded a high salary, if you can show that you receive recognition for your achievements and significant contributions to your industry by letters from your peers, from professional associations, from government associations, If you've won awards in your field, if you've published papers and things like that that have been cited many times, those are the kind of evidence you could use to show that you've earned that recognition. And another thing to note is that the government does look at the totality of the evidence to see if the body of the evidence that you submit tends to show that you are someone who is operating at a level that is significantly above what is ordinarily encountered in the field. So there definitely should be a good volume of evidence instead of just ticking the boxes. So exceptional ability would also require some advocacy and sufficient documentation. So that would be the way that you would meet the EB2 threshold. One other thing I forgot to mention regarding the degree, you want to make sure that if your degree was from a foreign institution, so if it's not a US university where you got the degree, it is very important to get the US education equivalency report to prove to USCIS that if it's a master's level degree, right, that the agency would know that it is the equivalent level of a US master's level degree. Because for some foreign institutions, the equivalency is not there. So if you're preparing for an NIW case, it's very important to get this US education equivalency report in advance so that you avoid any surprises when you're preparing the case. Sometimes you have a master's degree, and sometimes when you evaluate it, it comes out as a bachelor's level degree. You want to avoid that surprise, because in that case, you would need to prove 5 years of work experience, or use the exceptional ability pathway to qualify for the EB2. So definitely an important point to make sure that you deal with in advance. All right, so now let's go into a little bit more detail about the Matter of Dhanasar test, the three-prong Matter of Dhanasar test, which is the key inquiry that the government will look at on whether your case merits a national interest waiver. So let's start with the first prong requirement. You need to show that your proposed endeavor has substantial merit and national importance. Now, what does that really mean? Let's unpack that a little bit. So step one in the NIW process is to clearly define the endeavor, the proposed endeavor. And the government is very strict about the fact that the applicant must present a specific project or goal that goes beyond simply working in an occupation. So let's consider an example. Let's say you are an AI engineer, and let's say, what is your proposed endeavor? Now, you would write a statement that describes the specific project that you're going to do in your field of AI engineering. You would go beyond saying just that I'm an AI engineer and I'm going to be working for a US company such as Google or Microsoft or or Meta or something like that. That sentence is not enough to count as a proposed endeavor. You must go beyond that. So let's say, and this is a better example, I'm going to be researching this new technology of training AI models that is 50% more time efficient, time and resource efficient than existing models, because it uses this different algorithm to pull the data and use it for training models. And maybe you can have backup regarding your invention, such as maybe you wrote papers about it, maybe you've been presenting at conferences about it, and your proposal is basically that you will further develop this technology. And you can get a letter of intent from a university saying like, oh, we're interested in working on researching this technology with XYZ. So that kind of project-based proposal is closer to what we mean when we say what is a proposed endeavor, right? So it definitely needs to be more specific than simply saying that you're coming into the United States to work in an occupation. And clearly defining the endeavor is very important, because the government looks at the endeavor to a certain estimate its prospective impact. And prospective impact is what the linchpin is to see if a project has national importance. Because geographic scope is no longer the focus, but the government looks at whether a particular project will have global or national level implications for the field as a whole, as opposed to just benefiting a particular employer or just benefiting the immediate clients who use your product or services. So a broader impact to advancing a technology, that is the direction that you want to go. To show that your work has national importance. So let's take a closer look. So improved manufacturing processes or medical advances or substantial positive economic effects may have national importance. Benefit must go beyond one's immediate employer or clients, but must pose a broader impact to the field. Substantial merit is the easier standard, but you must achieve both substantial merit and national importance. National importance often focuses on the larger scale and broader impact of the endeavor. So again, and I said this over and over again in the presentation, but simply working in an occupation and simply, even if you're doing research, if the research will only be benefiting the bottom line of your direct employer, that is no longer enough to support a successful NIW case. So if you're working on a product at Google, and if that would improve the profitability of Google, that's the type of private localized benefit that the government will require Google to sponsor you for, right? So in order to use the NIW pathway, your work needs to be something that has a broader impact than that. And let's think about an example. Let's say you're developing a drug for a pharmaceutical company, and let's say that particular drug is going to be more effective than existing drugs in, treating a particular medical condition. And so if your research is commercialized and if a new class of drug is available to the market, then hundreds and thousands of people may benefit from this drug. It will improve medical practices because people will have better medical outcomes. It's going to have a direct impact on public health. And you can show that by, showing, that hospitals and other, research organizations are invested in your particular research product, and that it has that potential to significantly impact public health. So that kind of broader impact, that broader benefit to the public welfare, to, the lives of hundreds of thousands of people, that kind of a large scale impact can be a much better case for NIW, as opposed to a type of endeavor that tends to only generate a private profit for one employer or one company or the direct clients who happen to, hire that company for services. Similarly to, something like what a business consultant or investment manager would do, right? Even if you're dealing with a very, very large investment projects, if the purpose and effect of your project is just to improve the bottom line of the particular companies that happen to work with you, then that starts sounding like more of a localized private benefit rather than, something that will benefit the nation as a whole. So really, the nature of the endeavor, the nature of the benefit that can come from the endeavor, the nature of, who stands to benefit from this and by how much. So the scale is also important. Those are very important considerations when you're framing your proposed endeavor. Now, two other points before moving on to the next slide. Job shortage issues in the United States does not mean that the profession rises to the level of national importance. So, and this is a very common misconception that I used to encounter a lot in consultations in the past several years, is that if you're a pilot, you will qualify for an EB-2 NIW green card because the US has a shortage of pilots. And all you need to do is say that you're coming in to work as a pilot. Now, that is not true. Definitely, it's a highway to a denial because it is not the importance of the field that matters, but it is what is important is what you're doing within that field. And if you're just coming into the United States to be a pilot, even if the US has a urgent and serious shortage of pilots, that is not enough to get you approved for an EB-2 NIW. because the government's response is going to be this every time. They're going to respond saying, well, if there is a national shortage of pilots, sponsorship is the way to go. So the companies will sponsor foreign pilots to come in through testing the labor market and showing that there is no one in the United States in that region who is able and willing to take the pilot job. So that is the way that Congress intended job shortage issues to be solved. So the NIW cannot be used for that kind of justification. So that's 100% going to be a road to denial, unless you're a particular kind of, pilot researcher or an influential person in the piloting industry that's doing something that will improve the best practices of the field as a whole. And if you can show it by, convincing enough evidence, and that can be a different story. But in the ordinary case where you're just coming in to just simply work as a pilot, that will never work for an NIW in this, at this stage, at this stage of adjudication trends. Similarly, several appeal cases point out some relevant measures for national importance in terms of the work that teachers do. So teaching, it is important, interesting that USCIS takes the position that the activity of teaching tends to only benefit the students who directly attend the teaching. So by that, they take the position that this is not a broad enough impact that would qualify for national importance. So if you are a professor, for example, and if your work has both teaching aspects and research aspects, you may be able to qualify for an NIW if you can show that your research will advance scientific knowledge for the field as a whole. But if you're only saying that you're going to be teaching at a university and ask for, approval for the NIW based on your teaching plans, then unfortunately that's also going to be a way to denial, because in Matter of Dhanasar and in AO case law, we see many, many examples where the government takes the position that the nature of the activity of teaching tends to only benefit the direct students that receive the teaching and is a localized benefit, which is not what the government is looking for when they speak of national importance. All right. So the two other prongs that you meet for the Matter of Dhanasar. Second prong is that the applicant is well positioned to advance the endeavor. So the focus here then is on the applicant. So the government will look at the applicant's background in terms of their education and experience. They'll look at the applicant's track record of success or influence in the field. So let's say you are an entrepreneur and you're, developing a new startup business that can completely transform the way, a particular technology is used, or, some groundbreaking invention for the industry. Either you would show a track record of success with previous entrepreneurial endeavors that you've done that's related to this endeavor, or you would show a record of success by showing that you've already experienced a lot of traction and recognition for your progress in this particular startup that you're developing. So either with your past projects that you've done or with the progress of the current project, you'll still need to show that there has been this record of success and influence in the field. Patents, intellectual property, such as scientific articles written in scientific journals, published in scientific journals, being cited, things like that. That is always a good thing to show this influence in the field, because it shows that other experts are referring to your work. If you have patents, and if you can show that people have been citing your patent or been licensing your patent, things like that, that can also be very helpful to show that influence. And in the case that you're an entrepreneur, you don't even need to show that you are the inventor. If you can show that the patent was issued under the company's name and you are the CEO of the company, it can be linked to you, something that you've, helped develop as a CEO. You've led the development of that patented technology as a CEO. So you can use that. Even if you're not the personal inventor. Case by case, but definitely patents and intellectual property relating to any of the projects that you've led could be a helpful detail. How far along is the endeavor? So especially, yeah, if you're an entrepreneur, you want to show that your project has had evidence of traction, such as, being admitted to an incubator or accelerator, um, interest from venture capital funds on funding your particular project that can corroborate the fact that you're well positioned to advance the endeavor because you've already led the company to progress to that point. Contracts can also be helpful. Contracts with US agencies, major US industry players can be helpful. Really, not all contracts are helpful, but by showing contracts, you could potentially also support that you've already made enough progress such that those major industry players are interested in and invested in what you're doing. If you have already set up the business and if you've been growing the business to date, if you can show tax returns, for example, and Forms W-2 showing that your company is hiring dozens of employees, your company is making millions of dollars in revenues, all of those facts can also be very helpful towards showing that you're well positioned to advance the endeavor if you've already, grown the company to such a successful state. Third requirement for Matter of Dhanasar test, you also need to show that on balance, it would be beneficial for the United States to waive the requirements of a job offer and thus of a labor certification. And many different types of evidence can be used to help with the third prong. You can pull evidence that we already used for prong 1 and 2. You can talk about the broad system level impact that your work can bring to the United States that goes beyond just, saving one job spot for one, US worker. So you can make that balancing test by saying that the unique things that you can do to advance the field itself inherently has a broader scale benefit than applying the labor certification requirement for your particular situation. Similarly, with prong 2, you can talk about your record of success and argue that this cannot necessarily be easily replicated by someone who only has minimum credentials. Because what the perm requirement does is it requires the US company to find someone who's minimally qualified to do the job. But if you have superior qualities that is not captured, that is not adequately captured by the labor certification test, then that can be a justification of why you may merit an exemption from this procedure, such that, your unique skills and unique knowledge and experience can fully be used in furtherance of the proposed endeavor of national importance. So you can use evidence that you've already used for prong 1 and 2 to support prong 3. Finally, one thing to note is that entrepreneurs do have a leg up on prong 3, where entrepreneurs are usually self-employed and sometimes they're just not eligible practically for green cards under sponsorship, because if they have ownership interest in the business, you can't just have that business sponsor yourself for a job offer. So the ordinary labor certification program just doesn't fit quite well with the entrepreneur situation. So that can be another point in your favor when you're arguing prong 3, that on balance, it would be good to, grant the green card pathway to the entrepreneur, because otherwise they would simply just not be eligible to pursue that. So in conclusion, it is important to note that Dhanasar specifically notes that entrepreneurial work can lead to an NIW if you meet all of the 3 criteria that I talked about. And it is even important that the planned venture does not need to succeed. Ultimately, it is okay as long as the applicant can show that it is plausible that it would be successful by meeting all 3 prongs of the Matter of Dhanasar test. So definitely, it remains to be a viable pathway for entrepreneurs to qualify for a green card under EB2 NIW. All right, so just a few more detailed facts that we can talk about national importance, because often national importance become the linchpin of whether an NIW case is approved or not, right? Because what does it mean to show that your work will not only benefit your employer or your immediate clients, but what do we mean when we say your work will have a broad impact to the field, right? It's definitely not the easiest concept to wrap your head around. So let's look into it a little bit more detail. So you will need to prove the importance of your specific proposed endeavor, and it is no longer tied to just the importance of the field or the occupation the individual will be working in. So even if, the government really cares about developing AI technology, not every engineer who works in AI technology will be approved for an NIW. And surprisingly, not a lot of people know that. Expert letters can be very important to support a convincing case for national importance, because you can't just rely on general government reports or general executive orders that talk about the importance of a field. The national importance argument needs to be tied to your specific project. So what expert letters can do is they can fill the gap, right? And the experts from the field, and we can continue to use the example of AI technology, but an expert who is active in AI technology, they can write you a letter describing what the limitations of the technology that's existing is, and talk about what you're trying to do, and then describe what the prospective impact of your particular project is to improving this limitation or problem that the industry used to have. So that kind of expert letters that specifically target the prospective impact aspect can be very helpful for national importance, because that argument can be made very specifically to what you're trying to do in the United States. And as I mentioned multiple times, if you can only show that your work will benefit one specific employer, or, if you're an entrepreneur, your immediate clients, that will usually not be enough to support a successful NIW case. We need to be able to show broader impacts to a field or region or the public at large. So for example, and this is language that we took from the USCIS policy manual, a person developing a drug for a pharmaceutical company may establish national importance by demonstrating the prospective public health benefits of the drug, instead of solely projecting the profits that will accrue to the employer. Similarly, if you can show that there is widespread interest in adopting or licensing a technology that you're bringing, if you can show that you're developing a novel and important manufacturing process that will likely be adopted by other companies down the line, or if you can show that your technology is at the cutting edge of a competitive industry and stands to impact the development of similar technology by other companies. So, for example, if you're developing the world's first foldable phone, and if you're doing that with Samsung, Apple will want to do that, and Huawei will want to do that. So that kind of industry leading R&D projects can definitely be something that could meet national importance if you can convince the government that this will impact the development of technology for the field as a whole. Things like, if you're an engineer who's working on developing the world's first fully electric plane engine or hybrid electric plane engine, like those kinds of, cutting edge industry leading projects. If you can show enough evidence regarding that and the prospective impact of that, that can be a good basis for national importance. Substantial economic benefit. Creation of U.S. jobs at a level that is significant with respect to a population or an economy of a region. This can also be a basis for finding national importance, and we've done this where the economic benefit was very large. So we're talking about hundreds of jobs being created by a chain of companies that this person was developing, millions of dollars in investment in a particular region that is economically underdeveloped, and getting, I think we got letters from local senators and Congress representatives that talks about why this was significant for the region. That being said, if your business project is of smaller scale, so let's say your revenues are at the low hundreds thousands of dollars, and if you only have, a handful of 5 or 6 employees or things like that, that in itself will not be enough to meet national importance because the government will definitely look at that and say, oh, this is a localized benefit. So a scale really matters, and the government added that language significant with respect to a population or economy of a region. So that comparative assessment is now added to the USCIS policy manual. So if your economic benefit argument is of a smaller scale, then definitely you want to look into the other qualitative aspects of whether you can still show that your work will have an innovation to the field in terms of technological advancement, scientific advancement, or just, improving best practices for the field as a whole. So that qualitative argument you may want to explore in addition to economic benefits if the scale of your business is on the smaller side like that. All right, so now let's shift gears a little bit and talk about the details of what an NIW submission looks like. So what is included in an NIW submission? Definitely you'll include proof that you meet one of the threshold requirements for the EB2 classification. So if you're saying that you are advanced degree professional, you'll include a copy of your degree, diploma, transcript, and a U.S. education equivalency report if it's a foreign degree. If you're trying to qualify with a bachelor's plus 5 years, you also want proof not only of the bachelor's degree and the educational equivalency, but also proof of your work experience through detailed employer confirmation letters that show not only that you have worked for the 5 years, but that your experience has been increasing in complexity and seniority. If you are using exceptional ability to meet the EB2 threshold, you will include evidence that you meet at least 3 of the 7 criteria, such as, diploma, license, 10 years of work experience, recognition for your achievements by, your peers, industry, government associations, things like that to show exceptional ability. The other part of an NIW submission is a volume of evidence that shows that you qualify for the national interest waiver, the 3 prongs, national importance, well-positioned, and on balance. So these are some examples of the data you can use. So news articles, academic papers, market research can be helpful, and relevant data and statistics showing the need for your particular project, the limitation in the field that you're addressing definitely can work. But you also want to show evidence that's specific to your project. So if you're an entrepreneur, you want to provide a business plan that talks about what you're doing in the industry and how that will change the industry. And expert letters ideally from, government affiliated experts, but even, just with other relevant entities in the industry, talking about what the limitation of the field is, how your project will advance the best practices in the field, and what is the expected benefit from your work that you will develop in the future. So those kinds of expert letters can be very helpful for meeting the first prong. Some of the expert letters can help support well-positioned expert letters that talk about what you've done in the past and why those previous projects were impactful. You can use that to support well-positioned as well. Your resume, degrees, proof of professional accomplishments such as awards, patents, presentations at conferences, industry or media recognition, all of those types of objective evidences are very good to include to show that you've had influence in your field, which can also substantiate that you will have influence in your field with respect to a related proposed endeavor. Evidence of past history of success in a relevant field, history of influence shown by these objective evidence that we just talked about in the previous bullet, particularly important factors for supporting an NIW case. Entrepreneurs may also include proof of contracts, letters of intent, and startup capital to show that they are well positioned to develop the endeavor. Definitely, entrepreneurs can, use some non-traditional types of influence evidence to show, that they merit the NIW, and any other evidence that can show, the labor certification should be waived on balance, as I explained before, you can use evidence that you've already used for prong one, prong two, to show the broad impact of your work, to show that you have unique skills and experiences that cannot easily be replaced through the labor certification system. Any extraordinary ability kinds of evidence, such as, awards or having judged the work of others or being mentioned in media, things like that, that usually are relevant for the EB1A classification, but can also be used to support an NIW case. So actually there is quite a bit of overlap with the two classifications. So those types of evidence can definitely be helpful. All right. So now let's shift gears a little bit and talk about recent trends and strategies. First tip to note is that NIW has seen a significant increase in recent filings. And which actually does, I think, inform the way that the government scrutinizes NIW petitions a lot more than they used to. So in 2018, and this is only 8 years ago, there were only about 8,000 cases a year being filed under the NIW classification. Now, I think for the most recent year, fiscal year 2025, over 60,000 cases were filed. So it goes from 8,000 cases to 60,000 cases, which is a huge increase in only 8 years, really an exponential increase that you see. And so the government has definitely been tightening up their scrutiny of filings in the NIW classification. And I think those two trends are definitely linked, because RFEs and denial rates have increased across the board. So by the Q4 of 2025, the approval rates for NIW were as low as 36%. Approval rates 36%, which means twice as many NIW cases are being denied than they are being approved, mostly. Right now, it's hovering around 42 to 46%, which is still lower than 50%. So you can see that NIW is one of the heaviest scrutinized categories, such that over half of the cases that the government receives, they denied. So definitely important to make sure that your case stands out from the pack, because the default is that, it can be denied. The government also issued policy guidance in January 2025 that clarified several NIW aspects. So the policy manual that was updated in January 2025 still remains the standard that the government is following for NIW adjudication. We have not seen remarkable change, except for the fact that they are more strictly applying the guidance that have been published in January 2025. Entrepreneur-specific strategies. So entrepreneurs can benefit from a particular flexibilities in showing how their work is impactful. So if you can show things like significant media attention on your business or yourself, awards or grants from government entities, letters from third party industry, industry actors such as major venture capital funds or things like that talk about the prospective impact of your endeavor and how you're well positioned to do so. Those types of evidences can still very well support a successful NIW case. If you've received admission to incubators or accelerators, that can actually also be a very helpful, evidence of public interest in what you're doing. So those things can be very good to have. Intellectual property, such as patent publications, either by the applicant or the company, can be used and can be relevant for well-positioned and also national importance as well. Dissemination of results of your R&D through conferences, patents, licensing, etc., that can show, a broad impact that you've already made or a broad impact that you will make through your project. Letters from government agencies, I would say, is always a very, very helpful thing to have. Letters from U.S. government agencies, right? So if you're someone who is impactful in your local community, if you're already on an E2 visa, for example, and if you're creating a high number of jobs in your particular region, which is perhaps it's a economically underdeveloped region, if you can get a local senator or a House representative or even a state level House or senator, or even a city level government agency representative, supporting your case, that can be very helpful plus to your NIW case. So we've had a lot of success with those as well. Okay, what are some considerations when moving from a visa to NIW? First thing to note is timing. Premium processing is available for NIW applications, but it only covers the first part. So there are two parts to applying for a green card. The first part is the underlying I-140 petition, and the second part is either applying for an immigrant visa through your home country consulate or applying for adjustment of status by filing an I-485. The I-485 or immigrant visa petition cannot be premium processed, but the I-140 part can be premium processed. So an action will be rendered in 45 business days. If you use premium processing, you pay about $2,965 extra. But if you use regular processing, it will take a very long time to even get a response on the first I-140 step, over a year, well over a year. So we usually recommend clients to use premium processing because, you'll get the results faster and you can take next steps. Underlying visa status. If you are on a non-immigrant visa that does not allow for dual intent, such as TN, E1, E2, E3, etc., once you file the I-140, it may be more difficult to renew the visa. So definitely talk to an attorney before you do that. E2 visas is a little bit more lenient in terms of immigrant intent, but still you want to think about your strategy. And it also depends on whether you need the visa stamp itself or if you're trying to extend your status from USCIS. So definitely get in touch with us if you want to discuss the particular risk profile for your particular visa category. Dual intent visas, such as H-1Bs or L-1s, are not affected because, they allow dual intent. Application process. So you would first submit your I-140 packet with all the proof that you meet the NIW and EB2 qualifications. If your priority date is current, you can either concurrently file an I-45. If the category is backlog, you must wait until you can move on to the second step, which is the I-45 or the immigrant visa, which is also called consular processing. There are pros and cons to that. Briefly speaking, adjusting status in the United States, it's good if you are already here and you don't want to leave the US while the green card is processing. But the disadvantage of that is that you can't travel. So while your I-485 is pending, you can't travel outside without abandoning the application, unless if you have an H-1B visa or an L visa, and that you continue to use that to come in and continue work on H-1B or L status. But for all the other categories, you can't leave the US once you file the I-485 without abandoning it. Consular processing is the immigrant visa pathway. It can take longer in certain consulates, but it really depends on consulate by consulate. But you can continue to travel if you have that visa that will allow you to travel. But the thing is, you need to independently maintain an underlying visa status if you want to continue being in the United States. So really a fact-specific decision, whether you want to do AOS or consular processing. Definitely speak to a lawyer before making that decision. Some of the policy changes that came very recently on the AOS made it more risky to fall out of status while you're waiting for the I-485 to be adjudicated. So AOS actually can be risky in certain cases. So definitely speak to a lawyer before making that final decision. All right. So now the last thing is that we have a case study of a successful NIW case that you can perhaps review at your leisure. We're going to send you a copy of this PowerPoint so you can review that. Because I do want to leave some time for questions to see if any questions have come up. Let me see if we have any questions. Oh, actually, no questions that have come up till this point. And let me see if the Q&A function, Q&A, oops. Yeah, it looks like no other questions have come in with the Q&A function as well. Maybe I'll give or take 30 more seconds to see if anyone has anything they want to ask last minute. But otherwise, it looks like I covered most of what people were curious about. Okay, we have one question. Letters from TN visa are helpful to certify experience. And I'm assuming that we're talking about employer letters to either meet the progressive work experience requirement or to show that you're well positioned to advance the endeavor. Definitely, you can get letters from employers that's previously sponsored your TN visa, but you may want to modify the content a little bit because if you use the employment confirmation letter for the TN visa, maybe they don't talk about how your work experience changed over time. So if you're trying to prove progressive work experience, right, you also need to show that your job duties were changing upwards. So you want to have more experience, you want to have more complex duties. If that content is not there, then you want to maybe get in touch with the previous letter writer and say, hey, can you add this content in there? So it really depends on what function the letter would serve. If you're trying to prove progressive work experience, you may need to make some changes. If you're trying to just, prove that you're well positioned, maybe you can use that. But it may very well be likely that you may need to work a little bit to tweak the content a little bit to better fit what you're trying to prove. Okay, we have another question. I want to know, how can you transition from an F1 to green card as a student? And F1 to H1B in the meantime directly is possible. F1 to NIW can be a little difficult because if you're an F1 student and you're doing a completely new startup, for example, it may be difficult for you to have the work authorization to actually develop that endeavor. So if you get OPT, for example, or if you get STEM OPT, and if you can make it such that your business project is the employer, then if you have work authorization, then you can perhaps use that OPT or STEM OPT to develop your endeavor, and then you can transition to a green card. We've done that before. We've done that for a client who was on STEM OPT, and then transition to a green card. But also, we've had cases where the client transitioned from F1 to E2 to continue developing the business while the green card priority dates were becoming current. So you can think of different bridging statuses to give you more time to maintain underlying statuses while the green card process is ongoing. You can definitely explore changing from F1 to H1B. But the proposed endeavor must be aligned with that. So if you have a completely unrelated employer and they're sponsoring your H-1B, and then you have a completely unrelated proposed endeavor, like that's also going to be a little bit problematic. So you definitely want to talk to a lawyer on the right way to frame your proposed endeavor. But let's say you are somebody who, is doing a self-employment H-1B, which is also possible. You will still need to go through the lottery and get into the lottery, right? But you can possibly do a self-petitioned H-1B. And in that case, you could, continue to use that vehicle and then support an NIW case in the future. So yeah, there are many different options you can consider based on your specific facts. F1 PhD as a researcher, right? So you want to talk about you want to think about when your status will expire, and how will you maintain status while the I-485 is pending. So yeah, that would be the question. If you're a postdoc, for example, and if you're on an H-1B, then you could maintain status and then, have the NIW going that's related to your project. So yeah, really aligning the NIW argument with your particular status would be the challenge and would be an important consideration. Okay. All right, so we've definitely having more questions come in. Very specific questions. I think you can schedule a consultation. We will look more closely at that. Generally, work experience if you're trying to qualify with a bachelor's plus 5 years of work experience, the work experience must be after your bachelor's. Okay, so that's um, a general lesson that I can give is that if you're doing bachelor's plus 5 years, the work experience needs to be after the bachelor's. But if you have a master's, then you don't need that. Um, if you have a master's, then you don't need to show progressive work experience. You only need to show that you are well positioned to advance the endeavor. So definitely nuanced questions. I would be happy to look at your particular case if you schedule a consultation with me or any other experienced attorney. We look forward to hearing from you. Thank you for your participation, and I hope everybody has a wonderful day.